Hi, everyone. It's my pleasure to introduce our moderator for the next panel. Judge Patrick Bumate was confirmed to the Ninth Circuit Court of Appeals in 2019. Judge Bumate served as an assistant United States attorney in San Diego, where he was a member of the appellate and narcotics sections. He has also served in many important roles in the Department of Justice, including as counselor to the Attorney General, where he advised on a wide range of issues, including the National Opioid Strategy, combating transnational organized crimes, and civil enforcement programs. Judge Bumate has asked me to keep his bio short and snappy, so I have done as ordered, but many of you are probably already very familiar with him as he is incredibly generous with his time, always making time and effort to speak to our many law student and lawyers chapters. So with our deep thanks for moderating today, I will turn it over to you, Judge Bumate.
Thanks so much, Claire. Good afternoon, and it's a real pleasure to be moderating the last panel of this great conference. It's called Changes in the Role of the Judiciary, Restraint versus Activism. This panel will grapple with the role of the judge in the modern era. If you ask law school students today why they believe in originalism, the answer you often receive is that it helps restrain judges. They believe it enforces judicial restraint. And of course, judicial restraint has been the mantra of many, including legal conservatives, judicial conservatives, since my law school days. But as a judge, I've written often that judges may look to, and indeed sometimes they have a duty to adhere to the original meaning of the Constitution, even if the parties did not raise the issue. But is this the proper role of a judge? Is that judicial activism contrary to judicial restraint? This panel will tackle these important questions. We'll start with some metrics on the question, then look at how judicial selection may have impacted this question. Then we'll discuss some of the normative issues surrounding the issue. And finally, we'll discuss what these concepts mean for future litigation. So now I'll introduce our great panelists. Our first speaker will be Dr. Adam Feldman. We know Adam as the creator and author of Empirical SCOTUS, and previously as a statistics editor at SCOTUS Blog. Today, you may know him for his Substack, Legal Analytics, which applies statistical analysis to legal analysis. It's a great read. Next, we'll have my friend Rob Luther. Rob serves as professor at law at the Antonin Scalia School of Law at George Mason University, where he teaches federal courts and legal and judicial ethics. He formerly worked at Jones Day and served as an associate counsel to President Trump during President Trump's first term, where he worked on judicial nominations. And of course, as a first-term Trump nominee, I think Rob is excellent at picking judicial nominees. And then we'll have Shannon Coffin. Shannon is the chair of Steptoe's appellate practice, where he often litigates constitutional questions. He's served in several important executive branch posts, such as counsel to Vice President Cheney, Deputy Assistant Attorney General of the Civil Division. That's where I met him as a young 23-year-old paralegal many years ago. So, and then lastly, we'll have my colleague, Judge Jay Bybee. Judge Bybee has served as an outstanding judge on my court, the Ninth Circuit, for over 20 years. Prior to his judicial service, he headed the Office of Legal Counsel and was a law professor at the University of Nevada. So before we get to the questions and answers and the discussion, each panelist will now offer their opening statements. Adam, you want to get us started?
Absolutely. Well, thank you, Judge. So I'm probably coming at this a little bit differently than everybody else on this panel. I'm a political scientist as well as a legal scholar, and I do a lot of my work in data analytics. So I'm going to pepper this talk going both through concepts and history as well as the data. So I'll start out just by talking, and you can see I have some slides that I'm going to talk about when I reference some of the statistics. But first, in May 1954, the Supreme Court issued a decision that forever changed America. Brown versus Board of Education struck down racial segregation in public schools, declaring unanimously that separate educational facilities are inherently unequal. Today, this ruling is celebrated as a landmark moment for justice and equality. Yet at the time, Brown was viewed as undeniably activist, pushing constitutional interpretation beyond explicit text and precedent into the realm of broader principles like equality and social justice. The story of Brown highlights a fundamental truth about judicial activism. Whether one sees activism as courageous or controversial often depends on one's own perspectives and values. It works. Oh, okay. So what is activism? Indeed, activism isn't inherently positive or negative. It simply refers to how courts engage with the Constitution and laws. To some, judicial activism represents courageous judging, stepping forward to correct injustices, boldly interpreting constitutional principles to expand rights and liberties. To others, it's judges overstepping their constitutional roles, substituting personal beliefs for clear legal standards, and undermining democracy by encroaching upon legislative functions. The most prominent definitions of activism tend to relate to overturning statutes and precedent. Justice Clarence Thomas powerfully illustrated this idea in Gamble versus United States, arguing, if the court encounters a decision that is demonstrably erroneous, one that is not permissible interpretation of the text, it should correct that error. Thomas warns that clearly incorrect precedents amount to judicial lawmaking, breaching the separation of powers. For Thomas, what some see as activism is sometimes necessary precisely to uphold the integrity of the Constitution itself. By contrast, Justice Kagan in Nick versus Township emphasized the value of stare decisis, the principle of respecting precedent. She underscored the adherence to precedent promotes the even-handed, predictable, and consistent development of legal principles, preserving judicial integrity and public confidence. Kagan insists that reversing established law requires special justification, over and above the belief that the precedent was wrongly decided. Thus, activism from her perspective risks destabilizing the law and undermining public trust. Historically, the act of overturning precedent was itself revolutionary. Take the early 19th century Supreme Court cases of Rose versus Himley and Huston versus Goussier. Initially, Rose limited foreign judicial authority over property beyond their territories, yet only 2 years later, Hudson reversed course, mandating respect for foreign decisions under legitimate authority. This marked the first recognized instance of the court explicitly overturning its own precedent, showcasing judicial activism's potential to correct perceived judicial errors and redefine international law. Now, building on the congressman who spoke before us, Marbury versus Madison is often cited as the foundational case for judicial review and can be also seen as one of the earliest and most consequential acts of judicial activism. By striking down a portion of the Judiciary Act of 1789 as unconstitutional, Marshall extended the court's power beyond what was explicitly granted in the Constitution. This move was bold, arguably activist, and certainly transformative. But rather than being judicial overreach, it helped cement the judiciary's role as a co-equal branch of the federal government, capable of checking the other branches and safeguarding constitutional limits. In this light, Marbury demonstrates that judicial activism, when grounded in principle and institutional necessity, can only be legitimate but vital to the health of a constitutional democracy. Contrastingly, the philosophy of judicial restraint was articulated by James Bradley Thayer in the end of the 19th century, and it offers an essential counterbalance. Thayer's revolutionary views championed judicial humility and democratic deference, arguing that courts should rarely strike down legislation unless clearly unconstitutional. This represented and respected legislative expertise, prioritizing elected representative accountable to the voters, thereby safeguarding democratic processes and preventing judicial overreach. So here's some data. While overturning statutes is a clear form of judicial activism, an even more controversial one is the reversal of precedent. So this graph shows precedent in terms of the numbers each year by the Supreme Court, and the different colors are by the Supreme Court era relating to the Chief Justices. So it was in the 19th century, the reversals are rare, but it picked up towards the end of the 19th century. In the 20th century, amid social and political shifts, the court grew more willing to revisit its prior rulings. The shift began under Chief Justice Hughes during the New Deal era with cases like West Coast Hotel, which upheld minimum wage laws and departed from earlier established laissez-faire precedent. The Warren Court further accelerated this trend with a bevy of civil rights decisions, including Brown. The Berger and Rehnquist courts continued the practice, reversing precedents on issues from the death penalty to federal power. More recently, the Roberts Court, while generally selective, delivered a major precedent shift in Dobbs and, of course, more recently in Loper-Bright. These decisions show how power to overturn precedent can be one of the court's most potent and often polarizing expressions of judicial activism, while keeping bad precedent can perpetuate previous activist errors. Legal interpretations evolve, and what one generation sees as constitutional error, another may view as settled law, making the act of reversal both consequential and inherently contested. Judicial activism often refers to the court's willingness to strike down statutes passed by federal, state, and local legislatures. That's what you can see on the graph in front of you. The big green bars are the state statutes that were overturned. A historical view of the Supreme Court shows that such actions were rare in the 19th century, reflecting a cautious approach. But starting in the late 1800s and accelerating through the 20th century, the court began taking a more assertive role in shaping policy, seen clearly during the Lochner era, when it struck down economic regulations like it did in Lochner versus New York in 1905. Later courts continued this pattern, cases like Roe versus Wade, United States versus Lopez in 95, reflecting ongoing shifts in the court's interpretations of constitutional limits. Since the 1980s, the courts increasingly overturned not just state, but federal statutes. Those are the red bars in the, or rather the orange bars at the top of each graph. These shifts often mirror moments of national tension, suggesting that judicial activism is as much a response to societal change as it is a driver of it. Ultimately, examining overturned statutes show that judicial activism is not always overreach. At times, it reflects the court's responsibility to uphold the constitutional boundaries when other branches fall short, reminding us that the judiciary plays a central role in defining the structure of American democracy. This is a graph of the court's caseload over time since it was established and heard the first cases in the 1790s. Today, the Supreme Court hears significantly fewer cases compared to the previous eras, influencing judicial activism in nuanced ways. A reduced docket limits the court's opportunities to overturn precedent or to set broad policy agendas. However, it enables the court to focus intensely on a handful of influential cases each term, thoroughly shaping and defining legal doctrine. This deeper focus can amplify and impact each decision, turning select cases into landmark precedent and powerfully influence the future judicial interpretations and social policies. Interestingly, despite public perceptions of heightened judicial activism, the Roberts Court has not overturned precedents more frequently than past courts. This observation illustrates the complexity of evaluating judicial activism. It's not just about the number of cases overturned, but also about the significance, depth, and societal impacts of the decisions made. Ultimately, judicial activism demands a nuanced understanding. It's neither inherently good nor bad, but rather integral to the complex interplay among law, democracy, and society itself. In the end, the question may not be whether courts are activist, but whether their interventions are grounded in constitutional principle rather than personal preference. Of course, these practices aren't just limited to the Supreme Court. In a recent case, Duncan versus Bonta, our very own Judge Bumate, who I just wrote about this case, so it's kind of hot on my mind, dissented, highlighting a key concern with judicial activism, that well-meaning policy goals often cannot justify departures from constitutional precedent. As he wrote, "It's our duty to uphold the Constitution no matter how unpopular, otherwise we abdicate our role to the whims of the majority, the political majority of the state." His warning underscores a broader critique of activism, that when courts ignore or reinterpret precedent to align with contemporary policy goals, they risk undermining the rule of law and expanding government power beyond constitutional bounds. His dissent serves as a reminder that societal challenges, however urgent, should not be used to justify bypassing the constraints and safeguards enshrined in the Constitution. Activism can correct injustices or impose new ones. It can restore the Constitution's design or depart from it. Sometimes it's a necessary correction to legislative or executive excess. Sometimes it reflects a thoughtful reevaluation of precedent or an effort to restore constitutional limits that have eroded over time. The real concern isn't activism itself, but inconsistency or arbitrariness, when decisions appear driven more by outcome than by legal principles. Thank you.
Thank you, Adam. Rob?
Thank you to the Federalist Society for inviting me to the Reagan Presidential Library for having us, and to my co-panelists for sharpening my thoughts. I was born during the Reagan presidency, and he's the first president I remember as a kid. I've watched hours of his speeches and reflected even longer on his vision of America. But even more personally to me, in 1986, President Reagan invested personal and political capital to fight Chairman Joe Biden and the Senate Judiciary Committee Democrats to ensure the confirmation of the judge for whom I clerked, Dan Mannion of the Seventh Circuit. Judge Mannion was one of the great Reagan judges, like Scalia, Bork, Silberman, Sentell, Doug Ginsburg, O'Scanlan, Easterbrook, and Edith Jones. President Reagan also inspired my own dream of working in the White House and briefing the president in the Oval Office. Against all odds, I was able to do both. Only in America, or should I say, only through the Federalist Society. So I'm going to talk about three issues. Number one, the judicial nominations landscape that President Trump inherited. Number two, what people have said about the judicial landscape this term. And number three, what I understand judicial selection will actually look like this term. So I'm going to look at this through two lenses, form and substance. Form asks questions like, how will the composition of the Senate change the type of nominees selected this term? How many seats will be open to fill? Will blue slips still apply for district courts? And will any circuit seats be moved? Partisan composition of the Senate. The type of judge the president can nominate and have confirmed is different when you have 50, 51, and more than 51 votes. As you know, we're currently sitting at 53. Seats. On the question of seats, here's some data. There are currently 57 judicial vacancies. For comparison, when I was in the White House at this time, we had about 140. There are currently 6 circuit seats open, but only 2 of those have come open since inauguration. 3 of those judges will be Democrat appointees shifted to Republican, and 3 are Republican that will stay Republican. This is significant. We currently have 4 justices in their 70s. We have 38 retirement-eligible circuit judges on the date of inauguration. 26 are Republican, and 12 are Democrat appointees. So there's a total of 61 prospective circuit vacancies over the 4-year term of this Trump administration. That's everyone eligible to retire at the circuit level over this 4-year period. For context, President Trump in the first term had 100 prospective circuit vacancies from 2017 to 2020. He confirmed 54 circuit judges, so 54%. 54% of the current 61 judge universe would be about 33 circuit confirmations this term. But here's the other thing. The bulk of the circuit judges coming into retirement over the next 4 years are George W. Bush second termers, only 5 in total, and then the rest are Obama appointees. What they have in common is that there aren't many of either of them. If you assume that most appellate judges retire during the presidency of the party that appointed them, which the data from the modern era firmly supports, you'll be looking at something like high 20s and low 30s for Trump, as I mentioned. I see this having 2 potential consequences. First, the current landscape is reminiscent of the Bush administration, where every circuit nomination was something of a mini Supreme Court nomination. President Bush confirmed 64 circuit judges over 2 terms, an average of 32 per term. That's right around where I think Trump will be this time. Second, people, especially the president, will eventually start paying a lot more attention to the district courts, because there will probably be 3 times as many vacancies there as there will be on the circuit courts. So there will be a lot more time to care about them. Blue slips. This brings up the issue of blue slips on the district court. Senators from both parties have previously supported having complete veto over the president's district court nominees in their states. As we know, this policy was abolished for circuit judges under Chairman Grassley in late 2017. Nobody's talking about this yet, but I think that as time goes on, the abolition of district court blue slips will become something of a dominant theme at some point during this term. Why? Well, as I mentioned, at inauguration earlier this year, there were 26 retirement-eligible Republican circuit judges. Since inauguration, only 3 have given up their seats. Judge Jordan on the 3rd Circuit, Judge Ikuda here on the 9th Circuit, and Judge Sykes on the 7th Circuit. Only 7 of the 26 Republican appointees who are eligible to go senior became eligible to go senior during the Biden administration. That means that the other 19 have been eligible to go senior for quite some time and just don't seem to want to retire. Now, maybe that wouldn't matter so much if there were a bunch of Republican-appointed circuit judges hitting the rule of 80 this term. But as I mentioned, there aren't. There are 5. And 4 of them are chief judges, which means they're even less likely to go senior until the end of the expiration of their term. The moral of this story is that the bulk of circuit nominations this term are going to have to come from older judges who already declined to go senior under Trump during his first term. If those older judges don't retire, given the overall lack of judgeships to fill, and if the state district courts are sitting empty, I just think that at some point, President Trump or the Republican base will put pressure on the chairman of the Judiciary Committee to fill some of these blue state district courts with or without blue slips. Oh, one more thing. We didn't move any circuit seats the first term. We considered moving an Oregon seat to punish the Oregon senators for their mistreatment of Ryan Bounds, but this term, moving circuit seats could be back on the table. So that's form. What about substance? Substance is the kind of question or the kind of judges that President Trump will nominate now. The breadth and depth of this commentary differs a little, but I think essentially we're all saying the same thing. My former colleague, Mike Davis, who was on the Senate Judiciary Committee as Chairman Grassley's chief counsel when I was in the White House, has said repeatedly that President Trump should nominate judges who are, quote, even more bold and more conservative and more fearless, end quote, than those from his first term. 10 days ago, my good friend Mike Fregoso, who just left Leader McConnell's office and joined Bill Barr's law firm, published an article in the Federalist called "Why Trump's Judicial Picks Should Look Different in 2025 Than They Looked in 2017." This is a fascinating article, and I encourage all of you to take a look at it. As someone who worked with Mike and talks to him all the time, I think there are a few takeaways. In 2017, we were still operating under the old rules of the Senate and politics generally. We had 52 votes in the Senate, which ended up being 51 and actually 50 a lot of the time due to Senator McCain's illness. The Republican-controlled Senate was still somewhat skeptical of Trump, but then some things happened. The defamation of Brett Kavanaugh, Democrats breaking all the rules, and President Trump being elected in a landslide. So where are we now? The only rule is power, and prudential considerations that constrained selection in the past no longer apply. According to Mike, that should cause the White House to prioritize experience in the areas of law that matter to the based Republican wing and today. Even I have acknowledged that the selection process is likely to be tweaked a little bit this time. At the 2024 Federalist Society Convention in DC, we had a panel about judicial nominations, and I said, "It is my understanding over the next 4 years that there's going to be an even greater emphasis on whether judicial candidates have bled on the battlefield of the conservative legal movement. Candidates who have just been plodding along in private practice or government without ever facing public criticism are likely to be rejected by the White House. If that is a litmus test, so be it." During the first term, I used to ask interviewees to tell us about a time in their personal or professional life where they stood for principle and paid the price. In the same vein, moving forward, I think candidates could expect to be asked, "What have you done to prove that you share President Trump's worldview and judicial philosophy?" For example, such a question might be, "Do you believe that immigration law should be enforced regardless of public sentiment?" This is nothing new. This is not a loyalty oath. Judicial candidates throughout history have more frequently than not had some connection to the president that nominated him. And the president has the right to know what he's getting when he invests his political capital into a nominee. I expect to see more of that this time, and I'm fully on board with it. So look, Mike Davis, Mike Fregoso, and I were all intimately involved in judicial nominations during the first term. Each of us have emphasized fortitude, but this is nothing new. Fortitude was always part of our process, as I discussed at length in my Harvard Journal of Law and Public Policy essay, Judicial Selection After the 2024 Election. We started the trend of choosing circuit judges from state SG's offices and similar smaller boutique firms. We concluded that those people would be the best judges because they had the courage to take on controversial issues and stand up in court to defend them. I hope that trend will continue, and my understanding is that it is continuing. If there are Supreme Court vacancies this term, it's a foregone conclusion that they will be judges Trump appointed his first term. For lower court judges, the general pool is almost certainly going to be the same as last time because there's a minimum expectation of conservatism and talent. The American people have come to expect a certain type of nominee from President Trump. The question Mike Fregoso poses in his article is, where will the final focus be in this pool? Supreme Court clerks with strong views on administrative law, or former clerks to more partisan Republican judges who fight Democrats? This time, will the tie go to credentialism or conservatism? Mike encourages the White House to go with conservatism. Fortunately, I'm here to tell you that the White House is going with conservatism. High-quality conservative candidates. I know this because I've spoken to many of them who've interviewed already. I also spoke to Bloomberg about this Tuesday. I told them that originalist and textualist judges who are eligible and contemplating retirement, but who are concerned about the quality of their potential successor, should put that fear behind them. Dave Warrington and his team have been working incredibly hard, interviewing very impressive candidates, and they have picked up right where Don McGahn and his team left off. Nobody's going to be disappointed with the forthcoming nominees, except Democrats. We actually had White House counsel Dave Warrington at Scalia Law, and he's a graduate of our school, to speak last month. He was asked directly about judicial selection this term, and he said the plan is for him and his team to pick up right where Don McGahn and his team left off. So if anyone's wondering whether this White House's process will be much different than the first terms, I'm not sure you can get much more clear than that. Thank you.
Great. Thank you, Rob. Shannon?
Well, first, I want to thank Federalist Society for having us here, and my friend Dave Trulio, who runs this magnificent tribute to a magnificent president, which is really remarkable to be here in this panel. I think you're, really hearing some of the best and the brightest on this topic. I want to talk a little bit about what both Adam and Rob have talked about. I want to talk about judicial activism, but unlike Adam, I don't have anything to back up what I say. And Rob and I both dealt with judicial selection issues. I did in the Bush administration, and I think that the objective was always the same, and I want to tie the activism issue back to the judicial selection issue. So, and I want to begin my comments by noting how unhelpful I've always found the term judicial activism, because it means so many things to so many people. And we've heard various definitions that, that are accepted by various people from Adam. Judge Easterbrook called it judges behaving badly. And I think there's something to that, at least when you disagree with them. So the definition often depends on who you want to accuse of being an activist. One common definition, especially among liberal critics of the current court and even the Rehnquist court before it, is when judges overturn duly enacted statutes. But that seems to me to be an absurdly broad definition of the term. Since Marbury, and as Adam said, one can argue that may have been the ultimate act of judicial activism, it has been the judicial duty to declare statutes and other government acts to exceed constitutional bounds. So declaring a democratically enacted statute to violate the Constitution is not judicial activism. Generally, it is, at least in appropriate circumstances, part of the job description. That doesn't mean, of course, that judges should be lunging towards that objective. Proper restraint requires that a court do everything reasonably within its power to avoid declaring duly enacted laws unconstitutional. That's why we see judicial doctrines like constitutional avoidance springing up. If a statute can reasonably be construed to avoid a constitutional issue, it should be. But even that doctrine can be abused in service of overzealous judicial restraint. Take one famous example, and Jay and I, having worked together at DOJ at the time, I'm sure he will recall the angst it caused us, Public Citizen versus DOJ, where a majority of the court held that the Federal Advisory Committee Act did not apply to the president's consultation with the ABA during judicial selection, construing the statute's application to an advisory committee established or utilized by the president or an agency as the statute required, at least when applied to the president, to mean established or established. Justice Kennedy, to his credit, faulted the majority for twisting the plain meaning of the statute when the better answer was to read it as written and simply declare it to violate the Appointments Clause, or more specifically, the president's exclusive power to nominate federal judges, which Congress cannot interfere with. He wrote, the fact that a particular application of the clear terms of a statute might be unconstitutional does not provide us with a justification for ignoring the plain meaning of the statute. Don't twist the words just to avoid a constitutional issue. Sometimes you have to confront the constitutional issue. So the principle of judicial restraint can itself be distorted to reach bad constitutional results. There, the failure to declare unconstitutional a plain incursion into the president's exclusive constitutional power and to save a statute that didn't deserve saving when applied to the president, something we more or less drove a stake into in Cheney versus U.S. District Court when I took a lot of abuse in U.S. District Court arguing that case in front of Emmett Sullivan some 15 years later. I somewhat digress, and not for the last time, I'm sure. Another possible definition of judicial activism is the willingness of a judge to set aside precedent that the judge believes to be erroneous. This is, of course, a sin committed on both sides of the judicial aisle, and when defined that simply, it doesn't tell us much about the tendencies of a judge. The liberals on their court and their occasional allies had no problem setting aside Bowers versus Hardwick, which sustained Texas state sodomy laws, and Johnson versus Eisentrager, on which the Bush administration, especially OLC, had relied in establishing Gitmo as a holding place for enemy combatant detainees, while Roe was ready fodder for the conservatives once the issue was finally teed up properly for them in Dobbs. Adams provided some useful illustrations of the role of stare decisis in the jurisprudence of Justice Thomas and Justice Kagan. Justice Thomas famously never met a precedent he wouldn't revisit. But I think that even Justice Thomas has some limits, and I doubt very much that he wants to go back and revisit Marbury versus Madison. But the interesting contrast on the right was with Justice Scalia and a more measured, he was more measured in how he approached precedent, even precedent he might consider wrong. Then Professor Amy Barrett wrote an interesting article in the Notre Dame Law Review about the justices' originalism and the potential conflict with precedent, which Justice Barrett ultimately concluded wasn't that big a conflict after all, in which she notes that Justice Scalia jokingly called himself a faint-hearted originalist. What he meant, and what you would conclude from reading his many opinions, was that there were many issues that were simply too well settled to revisit, whether right or wrong. One example, and I did a lot of work in this space in the late 1990s and early 2000s when the court was active in the 11th Amendment area, was the interpretation of the 11th Amendment as reaching beyond the text of the amendment, which only addresses in its text the diversity jurisdiction of federal courts. And the court had long interpreted it, despite that text, with a constitutional gloss or a common law gloss to apply to the federal question cases as well. In Pennsylvania versus Union Gas, Justice Scalia declined to revisit that holding, which came from Hans versus Louisiana, which applied the 11th Amendment in federal question cases, because it was just too well settled a question, whether right or wrong. He actually thought it was right, but he said even if it's not, it can't possibly be denied that the question is at least close, and in that situation, the mere venerability of an answer consistently adhered to for almost a century, and the difficulty of changing or even clearly identifying the intervening law that has been based on that answer strongly argue against a change. Scalia was, of course, no shrinking violet in overturning clearly wrong precedent. He was a consistent opponent of the disastrous lemon test that my friends here at First Liberty love to complain about still, even though it's dead and buried. And you know, it finally met its demise after his passing. But despite their nuanced differences in approach to precedent, Thomas and Scalia often found common cause in deciding that a statute ran afoul of constitutional limitations, notwithstanding prior precedent to the contrary. In one of my favorite examples, Scalia was joined by Thomas in Dickerson versus United States in dissent and would have voted to overturn Miranda, which the majority relied heavily upon stare decisis to uphold, in part because, this is part of the opinion of the United States Supreme Court, because Miranda had become a part of our national culture, because it's on NYPD Blue a lot, which if you watched Andy Simplewitz, you would have known they abused Miranda on a daily basis. But having said that, they got their best confessions by tuning up a suspect. But part of our national culture. So in a typically biting dissent, Justice Scalia opined that far from believing that stare decisis compels this result, I believe we cannot allow to remain on the books even a celebrated decision, especially a celebrated decision, that has come to stand for the proposition that the Supreme Court has power to impose extra constitutional constraints upon Congress and the states. This is not the system that was established by the framers, or that would be established by any sane supporter of government by the people. As these examples illustrate, there are plenty of circumstances where allowing an incorrect judicial gloss on the Constitution to continue to control our polity is far from activist. So these simplistic definitions of activism, often applied by the left and the media, but I repeat myself, to show that conservative judges are more activist than liberals often miss their mark. I tend to agree with my friend and former colleague and Judge Bybee's principal deputy at OLC, Ed Whalen, who said that a simple tweak to these definitions gives a more useful, though certainly not free from doubt, definition of activism. It's not the act of declining to apply a democratically enacted statute, or to use a shorthand that Ed detests, invalidating a law, which Ed will say that's not what judges do. A lot of judges don't understand that. That gives rise to judicial activism. It's the wrongful judicial invasion of the realm of representative government. And that wrongful invasion takes place most often by imagining rights that don't exist in the text and tradition of the Constitution, as in Lochner or Roe or Bowers, or any of the accepted litany of judicial sins, at least among this crowd. And so defined, it seems to me that this is what the judicial selection process is meant to discern. Is this a judge that will make things up, or by contrast, take an honest approach to discerning meaning from an often less than crystal clear constitutional text and tradition? On the other hand, is this a judge that is too beholden to demonstrably incorrect precedent? Here, while there wasn't a ton of daylight between Thomas and Scalia, there are legitimate concerns about a court that reverses itself with every election. So while it's important to get the Constitution right, it seems to me, and to both Thomas and Scalia, that the constitutional precedent should have to be at least plainly wrong to upset that apple cart. And where that exact line is a question that requires a deep dive on judicial nominees, especially the Court of Appeals and the Supreme Court. To take one illustration, President Trump is now testing the continuing viability of Humphrey's executor by deliberately firing FTC commissioners that were the subject of Humphrey's executor. And that's, a decision, Humphrey's executor is a decision that's in quite a bit of tension with more modern thinking, modern in this case, correct thinking on the appointments clause, because it actually is modern thinking that looks back to the original understanding. But it still remains on some form of life support, at least. Discerning how a judge might approach that question of whether the president has a right to remove a multi-headed commission's members would be an important task in choosing the next DC Circuit or Supreme Court justice. If a justice thinks Humphrey's executor is flat out wrong, is it enough that it's been on the books for 80 years? Or 90 years at this point, and an entire administrative state has been built around it? These are weighty questions, to be sure, and the president's judge pickers need to have a clear understanding of where they would draw the line first before trying to figure out what their candidates would do. And I'm interested in discussing with Rob, during our Q&A, the question he would pose. But one last point, because I've probably gone on well past my allotted time, right, Patrick? Like the question of stare decisis, there's another consideration in judge picking, and one that's best illustrated by the Chief Justice approach to controversial cases like NFIB versus Sebelius and Dobbs. Many would say that's a concern for a steel spine, which of course is the most difficult thing to evaluate in judicial selection. But I actually don't think in the Chief's case, that's the concern. The Chief seems darn willing to take on the disapprobation of at least one side of a heated debate, as he did in the Obamacare taxing power decision. I think the Chief's concerns illustrate a different problem, an undue concern for the legitimacy of the institution, which one could, and I do argue, has the ironic result of undermining the legitimacy of the institution. So in looking at judges, the selection folks want to look for an indication that non-judicial political considerations about the court's role in society and culture and the NYPD blue problem might play a role in the decisions of the court. Again, from experience, Rob will tell you this, a very difficult task, and mistakes can easily be made, although I credit him and his colleagues for not making many, but it may be among the most important questions to answer in this process.
Thank you, Shannon. Judge Bybee.
Thank you, Judge Bumate. My thanks to my fellow panelists, and my thanks to the Federalist Society for its kind invitation to appear here today. So we live in an era of extraordinary political division. Some of the fissures in our political landscape have been demonstrated even in the panels that have served this convocation today. We have seen some divisions between libertarian and conservatives. We have seen some who are more Burkean, that is more slow walking in their approach to the kinds of changes that ought to be made, and others who are bomb throwers. And we are seeing some dramatic pendulum swings in the parties controlling the presidency and the Congress. So we have long looked to the judiciary for stability. To use Chief Justice Roberts' analogy, we are supposed to be calling balls and strikes. And to carry that analogy too far, there may be some flexibility in the strike zone, but any real changes in constitutional standards for a strike zone are to be carried out by amendment, not judicial fiat. The calling of balls and strikes ought to be a stable, dependable process. So what do we as Article 3 jurists do when we have a precedent that we regard as inconsistent with the Constitution? Depending on how you count, and with a great deal of respect for Professor Feldman's systematic study of these things, I'm just relying on the internet here. I just got these. I'm making these numbers up. The court has overruled somewhere between 150 and 300 cases. I'm not going to vouch for any of these, but I suspect that those are largely constitutional judgments, because the court has expressed its reluctance to overrule statutory decisions. The court's approach has long been that it is going to stake its position right or wrong, and that the Congress will tell it when it's wrong. So I'm guessing that most of those decisions that have been overturned by the Supreme Court are constitutionally based decisions. In Dobbs versus Jackson Women's Health Organization in 2022, the court explained the tension between the importance of having a constitutional issue settled and the importance of having it settled right. In a post-Dobbs world, what are the rules going to be for overturning precedent? I don't have any particularly novel suggestions for answering that question, but I do want to do two things. First, I want to suggest that it's important to have a set of neutral rules. Second, I want to move to the cases that I think the various sides might want overturned, sort of a set of dueling wish lists, if you will, as a warning to the kind of Pandora's box we may be opening up. So let's start with the idea of neutral rules. When I was head of the Office of Legal Counsel, I had to make judgments about the allocation of authority between the president and Congress. Many of those questions were non-justiciable. The president was going to stake his position, Congress would take its position, and it was not often that the judiciary was going to be able to arbitrate the line between those two. I regarded my role as head of OLC as protecting the prerogatives of the president. That didn't mean that I would take the position that the president could do anything he wanted to do. Rather, it meant that I was not neutral as between the president and Congress. If I thought there was a plausible, defensible, logical argument for the president's power, I had the obligation to protect his options. But there was an important corollary to that principle. I had to be neutral between this president and the next president, no matter what party she represented. Whatever presidential prerogatives I thought we were conserving were good in the next administration as well. I was neutral as between Republican presidents and Democratic presidents. So with that principle in mind, let's go to my second point. What cases might the Supreme Court be urged to revisit it over the next terms, and indeed over the next generation as that pendulum of control swings? The judiciary changes far more slowly than the composition of the Congress or the control of the presidency. But the pendulum surely will swing. It is swung from the Warren era to the Rehnquist and Roberts era, and it most surely will swing back. Whether that takes 10 years or 30 years or 50 years, there's going to be a pendulum swing back. So as I read these cases off, I'm going to invite you to imagine the consequences, legal, political, and practical, of overruling these decisions. And I'm going to ask you to also consider what happens if the next generation or the pendulum swing decides then to overrule these cases again. So I'll start with the cases I think the conservatives might wish to see overturned. At the top of the list, the easiest one right now is Humphrey's Executor. This one has been in the court's sight for some time. You don't have to be the oracle at Delphi to see that the court is ready to reduce the scope of Humphrey's executor, even if it will not outright overrule it. That, of course, will have enormous consequences for the independent regulatory agencies. Most of those end with a C. And it is quite possible that if the court actually overrules Humphrey's executor, that Congress will respond by making substantial changes in the organization of those agencies and make them single-headed agencies or fold them into existing executive agencies. A second one that the court didn't take up this last week, would be Kelo. That's the takings clause. This would be a much more modest change, but it certainly is one that conservatives would like to have in their sights. The big one on this list, the one that academics on both sides of the aisle often regard as deeply infirm, would be slaughterhouse. And the implications of overruling slaughterhouse are a thing to behold. If the court were to reinterpret what the court did in slaughterhouse, reread Section 1 of the 14th Amendment, and reinvigorate the Privileges or Immunities Clause, the clause that clearly was intended to do all the heavy lifting of Section 1. It would diminish the role of the Equal Protection Clause and the Due Process Clause, which were both utilized, and I use that term very carefully, they were utilized by the court to accomplish what they thought the 14th Amendment was supposed to do, but without the benefit of the Privileges or Immunities Clause. There are a lot of consequences that would follow from that. It would, for example, threaten Bowling versus Sharp, the application of the equal protection principle to the federal government, and take down cases such as Adirond. So the consequences really would be far-ranging as the court had to restructure the 14th Amendment. The fourth case on my list is Blaisdell. That's the Minnesota mortgage moratorium case from the Great Depression era. The contracts clause was the most litigated provision of the 19th century, and the court really read it out, as Justice Sutherland points out in his dissent. He's clearly right. The court just read the contracts clause out of the Constitution. It read it out of the Constitution, and then it took a clause that applied to the states and applied it, reverse incorporated it against the federal government. So if the court were to overrule Blaisdell, it would have two consequences. One, it would reinvigorate a contracts clause against the states, and two, the court would have to revisit whether there are any principles that constrain the federal government. So it works on both sides. Number 5 on my list, Wickard and Reich, which are Commerce Clause cases. That's Wickard versus Filburn. Number 6, Shannon mentioned, that would be Miranda and Dickerson, the exclusionary rule. Number 7, one that probably is in the sights of this Supreme Court, would be an Employment Division versus Smith. Number 8 on my list is Bivens. Number 9, New York Times versus Sullivan, First Amendment case. Number 10, Plyler versus Doe, dealing with the education of non-citizen children. Number 11, just for kicks, NFIB versus Sebelius, the Commerce Clause in the ACA. Now, not all of those would be dramatic changes. Some of them would be more temporary. There would be legislative fixes for some of those. But some of those, particularly in the case of something like Slaughterhouse, would be a wholesale reorganization of the Constitution, trying to restore its original intent. Now, that's sort of the conservative side that's the conservative list. What would be on the liberals list? Well, at the top of the list would be Dobbs. And you can imagine the destabilization of both the court and our feelings about the idea of a constitution being a kind of meta law by which we are constituted if a more generous liberal court were to come back and reinvigorate a more refined version of Roe and simply overrule Dobbs. Number 2 on the list, Heller and Bruin. Number 3, Citizens United. Number 4, Shelby County. Number 5, I've got Trump versus United States, dealing with presidential immunity. 6, Students for Fair Admissions. 7, Gregg versus Georgia, dealing with the death penalty. 8, Agassini versus Felton to reinvigorate the Establishment Clause. Number 9, Burwell versus Hobby Lobby, which would change the Free Exercise Clause. Number 10, Qualified Immunity. 11, just for kicks, Trump versus Anderson. Probably doesn't have much application, but I just threw it on the list for laughs. Which I didn't get much. That's okay. I'm all right with that. There are a number of decisions that sound in substantive due process that probably are not on the chopping block. There is probably not enough political will to attack these, even if they rest on shaky constitutional grounds. The first one I put on here would be Obergefell. The second would be Griswold. And the third, the two cases that survive the Lochner era. The two cases that were mentioned earlier today, because yes, we generally like these cases, and that would be Pierce versus Society of Sisters and Myers versus Nebraska, both dealing with parental rights, but both of them are clearly flat out of Lochner. My point in raising these cases is a simple one. If this court, or any future iteration of the court, is determined to get it right, we may see both the Constitution and the court destabilized. So we want to think this one through very clearly.
Thank you very much, Judge Bybee. Those are wonderful opening remarks. Before we get to any questions, I was wondering if any panelists would like to respond to anything they've heard from other panels. Adam?
I'll have to think about that one.
Okay, sure. Rob, anything you want to say off the bat?
I'm not sure the Democrats would really want to overrule Trump because they'll want those protections for themselves if they ever win again. Oh, yeah. So, Joel Heimer. I said I'm not sure the Democrats really would want to overturn United States versus Trump because they'll want that immunity for themselves if they ever win another election.
Shannon?
Yeah, but the top hits on Jay's hit list, I don't have any doubt that Dobbs and Citizens United and Heller, right? I mean, who has any doubt that they would throw that out? And despite the fact that they'd have to come up with some 400th iteration to explain Roe. So, they've never been able to actually explain Roe. And so reestablishing it is a bit of a task, but I don't have any doubt that that would be the case. So the one thing in Rob's comments is the question, right? And obviously you got that question so right in the first term, as we have evidence sitting here at the panel. And by the way, Judge Bumate is also evidence that you should always be nice to your paralegals.
That's right.
Because you may have to argue in front of them someday, because they're a hell of a lot smarter than you know. Was that NEPDG? The case that you worked on was the Vice President's Energy Task Force?
I did a lot of things.
Yeah, right. Yeah. Anyway, so I mean, the first term, I think they asked the right questions. I think it's a lot more challenging right now with threats of impeachment of judges who, rule against the Trump administration. What is that? What does the question mean about do you support Trump's worldview, right? The one that Rob is asking is, what's your position on separation of powers? What's your position on the First Amendment and free exercise and the like? I think those are the right questions. It's more challenging when are you going to rule when the pressure from the administration, not necessarily the president, but all the president's men is, are you going to rule for the president or should we impeach you, right? So, and that's less of a philosophy than an edict. So it's a very challenging question for candidates to respond to. I mean, I think if the answer, and of course no one's ever going to say that in an interview, right? I mean, but the question I was asking about Humphrey's executor, right? The president is pressing that issue. So you do want to probe on, the importance of precedent, the importance of the separation of powers and appointments clause issues there, and the power of the presidency. I mean, these are substantive questions, and I don't take Rob to be saying something differently. These are substantive questions that about the judicial philosophy, but I just find that it's complicated in the current environment, and I do hope that the White House will be taking the Rob Luther approach, that they're listening to you, about the importance of these principles, Because that's really, there are two questions: the principles, what's the philosophy of the candidate, and the character of the candidate. Is the candidate going to hold to those principles when they're under fire? It's just a very, very difficult question. Look, I don't mean to beat up on the Chief Justice, who's a friend of mine, and I don't want to get off of his Christmas card list. There was a much different question when John Roberts was originally considered as an associate justice. You'll recall the timing of, there was the associate slot for O'Connor, then the chief retired in, playing Sandra Day O'Connor in a way, in a brilliant way that was very typical of the Chief Justice. And John Roberts actually looked like a Chief Justice. And so, and if you go through the archives in this building and read the John Roberts notes, someone made a comment on the last panel about not being able to foresee. I can't remember exactly the comment, but the comment was about John Roberts and, not having a track record. I believe that's what the comment was. Actually, if you read his White House counsel notes, memos, you saw a man of steel. And that inquiry, I think, for associate justice, what kind of associate justice John Roberts would have been when the institutional integrity of the Roberts Court wasn't at issue, I think you would probably see a much different answer in some of these cases than you see for Chief Justice Roberts. Anyway, so.
Thank you. Judge Bybee, any other further comments?
Just two quick observations. Just to go to Shannon's point about the role of the Chief Justice. Many years ago at a Federalist Society meeting, one academic suggested that, this would be 25 years ago or more, suggested that when Justice Rehnquist came off as Chief Justice, that the president should appoint Justice Souter as chief. And the reason is because everybody who's ever been appointed as chief from the associate position has moved to the center. And this would move Souter to the right by appointing him as Chief Justice. So I just have one other point in response to, again, Shannon's point that there would be a very difficult time justifying Roe under the Constitution. But make no mistake, there are a number of other decisions that were on my list that liberals would like to overturn, for which there are good originalist arguments. These are close questions. Heller versus Bruin, the justification for qualified immunity, can all be attacked on originalist grounds. If you undo Slaughterhouse, the Equal Protection Clause doesn't apply to the federal government, which means that Congress could have race-based 40 acres and a mule remedies, including perhaps doing something about students for fair admission at the federal level, even if the states were prohibited from doing so under the Privileges and Immunities Clause or some combination of that and the Equal Protection Clause. So, we ought to be really careful, again, about what kind of Pandora's box we are opening up here when we start revisiting these things.
Adam, do you have comments?
So I was just processing as you were finishing speaking before, Judge Bybee, the precedents that you listed that the parties are looking to overturn. And it struck me that as a social scientist, putting the hat on for a second, that the time frame of the decisions that you discussed that the Democrats would like to overturn were much shorter in time. These are like mainly recent Roberts Court decisions. And I think that raises an interesting question about activism also. It might not matter at all, but should we let these decisions play out a little bit before we're so quick to overturn them? And studies have looked at this, right? How long, on average, precedent has been on the books before it's overturned. And I don't know if there's a right answer or wrong answer, but I do think that there's something to be said for letting these decisions play out in real time for a little bit before we're quick to overturn them.
Great. So I'm going to take some moderator's privilege and ask a few questions myself. So Adam, I thought your statistical analysis was fascinating. I was wondering, have you found any factors that correlate with the rate of overturning statutes? Like opposite president versus the appointment of the chief, or a new members of the court joining the court? Does that relate at all to the rate of how they overturn statutes?
Yeah, so this is a question that's actually been looked at since at least the 60s by a political scientist named Dahl, who wrote about this in one of the first quantitative articles. And so, yeah, it's generally statutes that have been on the books at least 4 years. And they say that, that the judges on the Supreme Court, the justices, are generally most partial to the incumbent administration. So they're waiting for not only the president, or not only for Congress to turn over, but for the president as well. So it's usually not statutes that are close in time. Is at least one thing that they've seen, and I think that has been augmented over time as we've had kind of more time for statutes to be on the books.
Great. And Rob, for those of you that listen to advisory opinions, one of the theses that they often portray is that it's not a question, the spectrum between the conservative liberal spectrum is not as important as really the institutionalist spectrum. Whether or not you pick judges that are more establishment oriented versus those that are non-institutionalist. Do you think that is a more important metric than your level of conservatism?
No, people have to remember this is a binary choice a lot of times, right? It's not choose your own adventure, create your own judge. I think that's where people make mistakes when they're doing this, is they hold the option in the universe of what's real against what's ideal. And, in most of these cases, you're looking at, folks who the senators have recommended. And that's why, anyone who thinks that Trump's going to nominate these crazy people, you're constrained by the institutional constraints. Home state senators for district courts, the expectation that circuit judges look a certain way, the Senate, 53 vote count in the Senate. And, the White House tends to choose people that they know for the circuit seats, and the senators tend to recommend their friends for the district court, and the White House chooses amongst that group. So, ultimately, I think those concerns are overweighed. And, if you just stick to the routine of choosing the best originalist, textualist candidate who has excelled throughout their career, who has an excellent professional reputation, who understands the separation of powers, and will uphold the rule of law, I think we'll continue to see high quality nominees.
Right. And Shannon, I agree with you that it would be too simplistic to say that judicial activism is just the act of striking down statutes. But do these concepts of restraint and activism, should they at least inform what standard judges should use to overturn statutes? In other words, do you need to be 51% sure that the statute violates the Constitution, or do you have to be 99% sure? What
No, I think there is a clarity requirement, right? And maybe even a super clarity requirement. Where the Constitution is reasonably interpreted in two different ways, there are reasons not to upset settled precedent. Where it's simply made up, and we have lots of examples, right? Where an error shouldn't, a clearly erroneous view just shouldn't take hold in the Constitution. Humphreys overturned Myers, right? Which was 10 years before. Why does that case get to win out, right? I think the threshold has to be high. Otherwise, you're just revisiting everything. And I think the concerns that Judge Bybee are raising, I don't disagree with at all. This is a very difficult question where two justices that no one would consider to be shrinking violets, Scalia and Thomas, had very different views, right?
And Judge Bybee, I was fascinated with your observation about pendulum swings on the Supreme Court. In your 20 years on the court, have you noticed any pendulum swings on the Ninth Circuit? I'm hoping so.
Well, the quality of judging increased dramatically when you joined us, Judge Blumenthal. Other than that, it's been pretty steady.
Yeah.
I will just observe that the Ninth Circuit has never been as liberal as we've been made out to be. The margins on our court have been close in the 20 years that I've been there. They've increased, they've shrunk just a little bit in various administrations. We had a number of seats that went unfilled for a number of years. We've been full for maybe the last 10 years or so. with just occasional vacancies that did get filled. The margins on the Ninth Circuit are far closer than people realize.
Great. Okay, now let's open it up to audience questions.
But never been as liberal? I mean, your point is in your 20 years on the court.
It's always been dominated by Democratic appointees, but the margins are close.
Yeah, because before you were on the court, there was a pretty good history of summary reversals, right?
Summary reversals is actually a good proxy for sort of being out of sync, and our number of summary reversals has reduced dramatically in the last 10, 15 years.
I agree with that. Yeah.
But no, there was a period where, and this goes to the point that Rob, did you make this about? Or somebody was making, maybe it's the earlier panel. No, it was the Congressman Issa, I'm sorry, about the new bill and spreading those appointments out over 10 years. The big increase in the Ninth Circuit comes during the Carter administration. It's a huge influx. Something like, I don't know, 14 judges or something like that the President Carter got to appoint because of legislation that didn't spread it out. And then those folks come of age in the Clinton administration, and then again, mostly during Obama and somewhat during Biden.
Okay, great. Let's turn to audience questions. We'll enact the Brest rules, so make sure that you actually have a question. But before you ask your question, please state your name and your affiliation.
Hi, my name is Sergey Vinkov, Riverside County, California. So could you revise a claim from the Federalist 78, the judicial branch is the weakest department of its sister branches? You can unfold this or reframe this question as intellectual weakness or financial weakness, whatever you prefer.
Does anyone want to take that?
Well, they didn't have Marbury versus Madison on the books at the time of the Federalist Papers, so that's one thing, right? They took a lot more power in 1803 than they had initially. But yeah, I think that it was already, the wheels were turning pretty early on in the Supreme Court.
Both Congress and the presidency have some independent authority under the Constitution. There are things that both of those can do, and they can move very, very quickly. The judiciary is because of our case and controversy requirement, is going to be, we're going to be reflective. That is, somebody's going to have to come into court, complain about it, and our processes are deliberately very deliberate. They're slow. The wheels of justice grind slowly to make sure that I think that we get it right. I think that makes us a little less dangerous because we're a little less precipitous, I think, in the way that we exercise our power. And it's very limited. Again, it's limited to cases and controversies. There are a lot of things that go on that the United States can do that are non-justiciable. And we're going to explore some of those during this administration, I am confident.
Go ahead.
Thank you. It's been 20 years since I appeared before Judge Bybee in a microphone and an en banc Ninth Circuit oral argument. Nice. Elizabeth Pfeffer from the Los Angeles chapter. When I was a first-year law student, we had a very close family friend who is on the Ninth Circuit. Carter appointed Arthur Alarcon, who explained his definition of judicial activism as judges aren't legislators. So judges can overturn statutes and precedents, but you're not a member of the state legislature. So my question, I think, is to Mr. Coffin about, since you mentioned the Lemon test being overruled, is it in the mix of perhaps the methodology of analyzing the constitutionality of a statute kind of in the mix? And I thought I knew the U.S. Constitution well before I went to law school, but I learned in law school that the Bill of Rights actually has a penumbra, and that penumbra emanates, and there's an emanation of the penumbra, and that due process isn't a procedural rule, like notice, opportunity to be heard, confront and cross-examine, but there's the substantive due process, and I thought, kind of like Justice Hugo Black, of either it infringes or doesn't infringe on a right, but I learned in law school that we have balancing tests like Lemon, but there's strict scrutiny and rational basis, and it seems that kind of opens the door for judicial activism because, well, if I like Congress's stated intent, I'll kind of give it the deference, and now that's a good enough reason, to shut down free speech because I agree with Congress's reason, but I don't agree with the reason. So wondering if things like substantive due process itself as a concept of a way to interpret the Constitution And just like Lemon is gone, if we've got rational basis, and if it's just bright line, does this infringe or not? What are your thoughts on that?
Can you repeat the question?
I could, but I won't.
Well, Justice Scalia, in the Commerce Clause context, was, hated balancing tests, just hated them. And one of my favorite quotes from Justice Scalia, and I always forget the case, but someone sitting here smarter than me will remember, is, he was talking about the balancing test when there's not facial discrimination against commerce in a statute. And he said, where you're balancing state interests versus the federal interests. And he said it's like asking whether a particular line is longer than a rock is heavy. These aren't tasks that courts can undertake any better than you or me.
Unless you know where you want the result to be.
They ask a policy question, and those are difficult. We shouldn't be asking our judges to make those judgments. And Lemon was notorious for that. So the court has moved away from these sort of multi-factor analyses, and looked more for bright lines where they can. I hope that responds to your question.
Right, I was wondering if there's going to be more of a global, at some point, if balancing tests are gone. Either it infringes or doesn't, violates the rights or it doesn't.
Yeah,
Due process was satisfied or wasn't satisfied.
Yeah, and I think that's what the court has moved more towards as a general matter, that we just, we're not very good at doing these multi-factor analyses. So.
Right, thank you. That's what AI might be for, right?
Thank you very much. Next question?
I'm the non-lawyer, I guess, in the room. I'm here
What's your name?
as a guest, Jordan Allen. I'm a film director. I'm just a friend of Shannon's. He invited me, and the first thing...
and I didn't want to answer any of your questions.
I know, he doesn't, and that's just like in life. But when he did invite me to this, I thought it was very timely. Obviously, given the week we had with Judge Boasberg, you're talking about activism is now in the mindset of everyday Americans, which I think is really great for the Federalist Society, because I remember when filmmaking became sort of like a sport, so to speak, where like the days of Cinemagic magazine was obscure. Now everybody says, hey, do you have CGI in your movie, right? So now you guys are in a world where if you bump into somebody in the supermarket, everybody has something to say about the law. And what's going on in America today is fairly obvious. You have a political divide. But I think what Jay said about balls and strikes is absolutely the most absolute. That's the Constitution. And the idea is nobody should panic when they judge shop, as we know they do, and they go to this state looking for the San Francisco judges, and they get the ruling they want to overturn, in a sense, what the rest of the electorate has already decided back in November. And it frustrates people. And then even Judge Boasberg feels inclined to make a statement. He said, well, I wasn't ruling on the deportation. I was ruling on the Aliens Act. If they, in a sense, he's inviting a refiling. But what I found really disturbing, and this is what I want you guys to speak on, is jurisdiction. In the moment that they were doing the ruling, there was a lot of controversy over where the 5 people, and the people talk about all the people on the airplane, all the people that landed in El Salvador. But if you really break it down, the people that were being presented by the ACLU were 5 individuals. So in essence, the only order he could have made was to protect the rights, in theory, of these 5 individuals. But he attempted to overreach, in my opinion, and say the entire airplane with everybody should turn back and come back.
So, Jordan, actually, we were discussing this earlier. This discussion about nationwide injunctions. Typically, when you see nationwide injunctions, it's a single plaintiff case. and maybe it's an APA case. Of course, the APA does say you're supposed to invalidate actions but typically what you've seen, and we dealt with this in the Bush administration a lot at DOJ, is a single plaintiff case, and relief. The relief issue is where the judge expanded, from a single plaintiff to a large group. Actually, Judge Boasberg didn't do that. In fairness to him, and you can argue whether he was right or wrong how he did this, but at the TRO stage, in a very compact amount of time, he provisionally certified a class. He went through that analysis in a very shortened time, but he did provisionally certify a class, and you can criticize whether that's an appropriate thing to do at the TRO stage. But that case is not a particularly good example in my book of the nationwide the nationwide injunction, because he actually was granting an injunction as to a certified class or provisionally certified class. But look, the nationwide injunction thing is a problem that both sides of the aisle have been dealing with, by definition, it's expanding well beyond the dispute and the parties before the court. It is a remedial issue. It's a hard thing for courts of appeals to really get a handle on, because courts have been allowing this sort of thing forever. It really is a thing that invites congressional action, and God forbid Congress do something. But it really is a sort of a policy problem, and an issue that Congress should be addressing whether and how that sort of relief should be allowed. So.
Okay, I think we have time for one last question.
Hi, I'm Eamon. I'm from Silicon Valley. The last guy stole my original question, so I'm going to ask a different one. So it seems like a lot of judicial activism that we want to criticize comes from Congress leaving a void of activity, not doing their job, and the judiciary eventually feeling compelled in some way to step in and fill that void. And we can talk about whether that's good or bad, but I was hoping you could comment on, is there a role in the judiciary for encouraging Congress to do its job more? Or is there a certain action that the judiciary can take? Or do judges just have to stubbornly stay within their bounds, come what may, and not exceed the power that they're supposed to exercise?
A friend of mine wrote an article once called Remanding to Congress, and that's not a remedy we have. We can remand to district courts, we can remand to agencies, we can't remand to Congress. We just hope that Congress gets the message. But the problem of the gaps in legislation, really interesting problem. And of course, during some periods of the court's history, we have tried to fill in those gaps by improvising things using the Equal Protection Clause or the Due Process Clause principally. And that creates a different set of problems.
Also, just to kind of build
1 minute for last word.
I'll be quick. When you look at the polarization in Congress, right, it's increased quite a bit over the last several decades, and that I think creates more of a mechanism for Congress to have difficulty in actually coming to clear legislation, and that leaves the gaps for the courts to fill or not. But it does create a very slow movement in terms of new policy. And so that vacuum is there, and while the mechanism for judges to push back to Congress, there's nothing directly there. I think it's definitely a sign of the times that there's more of this, and I don't think it's going away anytime soon.
Okay, thank you. That will be the end of this panel. Thank you very much for this excellent discussion.